We're going on the record.
You're on the record.
Good morning and welcome to the third day of the Maryland Public Service Commission's rulemaking with respect to supplier consolidated billing regulations in COMAR Title 20, Subtitle 51, 53, 54, and 59. Over the past 2 days, we've spent our attention on very detailed regulations with respect to customers that have or will have trouble paying their utility bills. Beginning today, we will touch on other issues involving supplier consolidated billing. Before we get started, are there any preliminary issues?
Yes, Mr. Chairman, I have a couple.
Mr. Baker, good morning.
Good morning, thank you. 2 points. One, the work group is aware of a conflict that Mr. Kane of Washington Gas has at 2 p.m. on Friday. And so the parties would like to request the commission consider starting the hearing on Friday at 9 a.m. if you are amenable.
Do any of the interested stakeholders object?
As of the work group meeting last night, no, but I will let the parties weigh in at this time.
Do the commissioners object? Seeing no. And
Mr. Chair, I would just ask that we should do that, I think, to accommodate that. But if things go swimmingly today and tomorrow, we may not need to do that. That's the only thing I wanted to point out.
Thank you. Alternatively, if things go the opposite way, we're not going to rush this, and we may need to continue this into next year. Thank you, Mr. Baker. Other items?
Thank you. The other item is the work group discussed last night, and we would like to request moving the licensing discussion from this afternoon, if we were to reach it, to Friday afternoon, and instead start the material that we were going to cover tomorrow morning this afternoon, so that we can continue discussing the operations of SCB holistically instead of bouncing between the licensing and the operations of supplier consolidated billing, if the commissioners are amenable to that modification to the schedule.
Thank you, Mr. Baker. Other items?
I believe that is it. We do have some red line that we revised from yesterday. We were able to modify most, but not all the COMARs per your direction. I can present those now, or we can bring them back to you tomorrow as a holistic set.
I would advise bringing them back tomorrow when they're
okay. Thank you.
Other parties, preliminary matters. Mr. Green, you had seemed like a quasi request yesterday. I sent you on a homework assignment.
Right.
Where are we today?
We did discuss the issue of, I guess you could say, ongoing discussions among the working group last night during the working group sessions. I think where we are is that there were a couple of working group members who, I don't want to misspeak, so if I am, I hope that these parties will correct me, that were on the fence about whether certain items needed continued discussion, and there were others who have indicated both yesterday in the working group session and to me offline that they were willing to continue discussions on certain issues. And I think where we left off was that we would continue to see how the week went and how many issues we are talking about in terms of the guidance that we're receiving, and how to either take the guidance and reassess our own positions in order to accommodate everybody and address the concerns, or to take the guidance like what we got yesterday, which was go work on this, all of you. And so we're working through that. But I will give another report, I think, after we meet today. But I do think that a lot of the parties are willing to have certain discussions, and as long as it doesn't delay anything too much into the future, and we're on board with that as well. We don't want to seek a long delay.
I'm glad that the parties are using the afternoon to work together with each other. So what I'm hearing from you, Mr. Green, is you do not have a motion or a proposal for the commission at this time. At the end of the day, I recognize that this is your petition, your client's petition. We would not be here spending this week on this regulations, but for the petition you filed back in 2017, I believe, September of 2017. The fact that many of the concerns of the parties were not aired until, or became known to the commissioners until October of this year, may come as a surprise to some of the parties. Of course, if at any time a work group, this one or others, reach an impasse that needs input from the commissioners, parties are free to seek that rather than learning of the positions of commissioners in the midst of rulemaking as we're redlining various competing proposals. So I just wanted to get that onto the record. All right, Mr. Baker, we shall proceed.
Mr. Chairman, can I also just add to what you've just said? As you noted, we're learning about this and learning about the positions as we go here. And so there are some areas that Mr. Green did raise yesterday that were of particular concern to the suppliers. So knowing that, and knowing that I may have still some questions, I would like to just, reinforce what Mr. Green said, that there are some of this guidance with more information could change, particularly on some of those first issues that was brought to my attention that were particularly concerned on posting. That there was I think the distribution versus commodity, but then there was also the bundling issue that I would like to know a little more about. So I don't know how this process is going to play out, Mr. Chairman, but if there is a look back envisioned, I would just be interested to know when that might be and how we might, further consider the guidance that we've provided up to this point.
Well, as I've stated from the beginning, we've been taking informal votes throughout this week. Mr. Green, we will wait to see if you have any proposal at a later date. Perhaps you will, perhaps you won't. And then the commissioners will have regulations that they will need to rule on eventually. Mr. O'Donnell?
By way of just commentary at the beginning here as well, I just want to reiterate a point I made yesterday and I think is very poignant today, and that is, although Mr. Green's clients are the petitioners and we appreciate that, and we wouldn't be here except for their petition, these regulations will apply to every supplier out there. And Mr. Green's clients, a very important part of the industry that we want to support in this state, are probably, I think he said 15, represent 15 or so affiliate interests. There are a lot more suppliers than that in the state, and we need to make sure that the spectrum of quality of that supply is important to us as we look to the health of retail supply in the state. And we're writing these regs for everybody, not just for the petitioners. So I just wanted to reiterate that because I think that's something that gets lost sometimes and is very important. And Mr. Green and I have talked before, outside of the context of these proceedings, one bad actor can really do damage to the integrity of the retail competitive industry.
Thank you. At this point, Mr. Baker, if you'll take us to our next topic.
Thank you, Mr. Chairman.
Mr. Baker, we lost you. We heard you and then we lost you.
Am I back now?
You're back.
Okay, my apologies. Thank you, Mr. Chairman and Commissioners. The first topic I would like to cover with you today is the subject of Bill View Access. Ms. Knoll, would you mind pulling up the proposed regulations? It should be 2053-05-09, I believe, in the electrics. Or actually, it should be 07. Thank you. It's already up. So, Bill View Access. The proposed regulations would allow a supplier to provide back to the utility information on the customer's bill that the utility had provided to the supplier. So what was printed on the bill, but it does not mandate that the suppliers provide the entire bill and all the charges that were on that bill to the utility. The reason for this exclusion is twofold. One, there was concerns by the suppliers of the bill of their bills being used for marketing. Well, mostly it was all about marketing and customer acquisition, and so suppliers were worried about the use of the bills for the utilities to attempt to acquire customers. There was also concerns with their information being considered confidential or market sensitive, such as the prices of their other services that are unrelated to commodity. Staff would like to note that already in COMAR today that there is provisions against a utility from marketing standard offer service. But with that stated, staff was sympathetic to the concerns of the suppliers and agree that some charges on the bill are unnecessary for the utility to see, and that there could be possible enforcement issues of ensuring that they are not data mining the bills. One, I think, important note, though, that I would like the commissioners remember is that in the customer disputes, the work group never reached full resolution on how customer disputes would be handled. And so what was envisioned at the end was that if a supplier receives questions about the utility portion of the bill, while they might try and answer questions, they would eventually end up referring that customer back to the utility, who would be the point contact to discuss the utility's information and charges on the bill, which is part of the reason the utilities would like access to the entire bill. The other issue is, and one other utility also was hoping to use these bills as part of their quality control on charges sold back to the utility. Though staff would note that we already have reporting requirements for those, and so we don't think the bills would be necessary for that. So that would be the first part. That would be C1. C2 would be if the supplier does provide complete access to their bill, that the utility could not use the information to market standard offer service, research, or market other services, and that they would be allowed to share that information. They could not share that information with non-regulated affiliates or other non-governmental entities without permission from the suppliers. Staff believes these proposals are appropriate, that they provide the utility the information they need to assist customers while also protecting the suppliers' perceived confidential information. With that stated, staff is available for questions. Thank you.
Mr. Baker, I'm having trouble understanding item number 2 here. I'm not sure if it may just be me. Can you walk me through what 2 says?
Yes. So C2 is meant to govern if a utility has full access to the supplier consolidated billers information. So if they have access to the commodity charges or other value-added products on the bill, in terms of that bill information, they would not use that information to market standard offer service. There would be a prohibition on using that information to research or market other utility services such as Empower, and that they could not share that information with their affiliates or other entities unless they had explicit permission from the supplier. They could share that information, though, with the Commission or OPC, since those are governmental entities.
Thank you. I was just having trouble reading 2. Perhaps there's a few words missing in that regulation.
Okay.
Or perhaps
We can look at it.
made more clear. Let's hear from other parties. Beginning with the petition.
Okay, I think that's got it. Your Honor, we oppose the requirement to provide the actual bill to the utilities. You have to remember, under SCB, the utilities will be transmitting electronically the information, the utility charge information, and it is bill ready, so that information goes directly onto the bill. So the utility knows what charges that have been sent, and so our view is that all they really need to know is if they need us to send them back the information that they sent us to verify that yes, this information appeared on the bill. That's our proposal, and that's the red lines that we submitted. Under SCB, if a customer has billing questions, they should call their biller, which for SCB would be the SCB supplier. And like Mr. Baker indicated, there was working group discussions of how far should an SCB customer service representative get into answering questions about a utility bill. And I think we declined to propose any kind of rules or orders or excuse me regulations encompassing that, because I think it's largely what happens today, right? I mean, under UCB, the customer, if they call the utility and ask questions about supply charges, the customer will be referred to the supplier and vice versa. Under SCB, if a customer were to call the SCB supplier and ask questions, so if they were very high level questions about the utility charges, the rep could answer those questions, such as, what are these charges? Oh, those are your utility charges. But the minute they start to drill down into a particular charge, at that point, it's likely appropriate that the response would be, you need to call your utility if you have questions about specific utility charges on the bill. But to answer the question, the inquiries that go into the utility service center, they don't need to see the entire supplier bill. If there's questions about how a payment was posted to the supplier bill, that's the supplier's responsibility. If there's questions about the supplier rate, that's the supplier's responsibility. So that there's a question of whether they need it. And then the second issue is the fear that the utility may use the supplier bill as a data mining gold mine. And we're going to have every bill from a supplier is going to be different in format and substance, different prices and products and presentations. To have all of that in one place, it's very tempting to go mine that to see what's the pricing out there, especially when the utilities are offering similar type products separate and apart from SOS that appear on the bill. You can go to bgmarketplace.com as an example and see the other types of products that appear on the bill. And we talked about that in the February 2018 hearing, that utilities are continuing to get into that and continuing to try to offer products other than SOS. So and sales service. So those are both the need for it and the competitively sensitive concerns that we have. And then we also, building on what staff had in number 2, there may be suppliers that just say, I'll just send you my bill. They don't want to have, if there's a separate electronic format that they feel they have to build in order to provide information on utility charges back to the utility. So we left that option open, that if there's a supplier that wants to send them the bill, they can do that. But those are our concerns. This is actually a really important issue to the petitioners. I think I know in our October and again in our December comments, the two biggest important issues, as we've discussed, are the payment posting and the bundling charges issues. But a number 3 issue on the pecking order for us was this bill view access issue. And I just wanted to underscore the importance of that to the commission. And I'm happy to answer any questions.
We'll turn now to the utilities to hear their rebuttal or response to the petitioner's position.
Good morning, Mr. Chairman, Commissioners. Oh, I'm sorry. Robert, do you want to go first?
You can go ahead.
Oh, okay. Thank you very much. Mr. Chairman, the petitioners had 2 points, and I also have 2 points. And like the petitioners, my points correspond to C1, more or less correspond to C1 and C2 in the draft regulations. Right now, we give suppliers full bill view access. And all of the arguments that Mr. Green just made about, well, the utility doesn't need access to our bills, would correspond fully to what the suppliers have asked for from us and which we are already providing to them. So it's very much a why do you need bill view access from the utility, but you can't provide or won't provide bill view access to the utility. And it's important, we see this as important from a customer relations standpoint and a customer satisfaction standpoint. If the supplier is in fact going to be able to answer all of the customers' questions all of the time, and we're never going to have to hear complaints or answer questions from customers who are on supplier consolidated billing, then there is less of a need for us to have full bill view access than there otherwise is. But if customers are going to get sent to us to answer questions, and that's the way it will work in the real world. And right now, customers do get shuffled back and forth between the utilities and the suppliers, and that's going to at least be as much, if not more, under supplier consolidated billing. We need to be able to answer customers' questions too, and it's going to produce frustration and a bad experience at both ends, both at the supplier end and at the utility end. In our dealings with the customer, if the customer is getting ping-ponged back and forth, and we have to answer questions by saying, well, we don't know what you're talking about because we're not allowed access to that information on your bill. So that is why from a customer service standpoint, we believe it is both appropriate and necessary for the utilities to have bill view access. That's the first point. The second point is this parade of horrible things that the utilities are alleged to be capable of doing. I don't think they're going so far as to say we will do it, but that we would be capable of doing if we're granted bill view access, and that are reflected in proposed C2. Well, if you have, first of all of that stuff's already forbidden, with one exception in C2 sub C, which I will want to just close out by talking about. But all of that is already expressly forbidden by existing provisions of COMAR for us to do. We can't scoop information and give it to our affiliates, and we can't market standard offer service. So that said, C2 represents belt and suspenders, and if you really want to say in the regulations at least twice that we can't do things, that's fine. But having C2 eliminates the argument against giving us bill view access in our view. Now, as I said, there's one nuance to C2 that, quite frankly, we haven't. I don't think we've raised this even in our written comments, and I just wanted to point it out this morning because looking at the language fresh this morning, it does cause me concern. The language "or any non-government entity." Okay, I'm all fine with you can't share the information with our unregulated affiliates. That's, like I said, it's already forbidden. You want to forbid it again, that's fine. But I am concerned about that phrase "or any non-government entity" without express granted written permission of the customer and the supplier, because we could get there's a hypothetical and a real. The hypothetical is we get subpoenaed by some third party that doesn't happen to be a government, and then we say we can't give you the information because of this regulation. That's at best awkward, and at worst that's an infringement on the rights of other parties that might need the information about the supplier relationship for some purpose. And as I think about it, it also says that if the customer asks for information, we can't give it. We'd obviously have that customer's permission, but we'd also have to get the supplier's permission. So the supplier could block us from giving the customer their own information. But that's the hypothetical. Here's the real world concern that grabbed me as I was reading this morning. We have to do power supply settlements relating to every supplier every month through PJM. I don't know, do we count PJM as a government entity or a non-government entity within the meaning of this? Because if you don't count it as and I don't think it's a part of the government. So if it's a non-government entity, what this is saying is we can't settle our bills with the our supply bills with the supplier every month through PJM. And that obviously is completely and utterly unworkable. So no matter what else we do, I would respectfully suggest we need to strike or any other government, non-government entity, those words, from C to sub C. And for the reasons I just walked through, I think this whole idea that we don't get bill view access is a bad one. It's bad for customers. It's bad for the relationship between the utility and the suppliers, and it's chasing a problem that already doesn't exist.
Thank you, Mr. Kane.
Yes, I would like to basically echo what Potomac Edison echoed, that we basically need bill view for the customer experience. Customers are going to ask us questions about their bills and charges, and without that information, we won't be able to answer it. In addition to that, we're not in, for Washington Gas's purposes, we're not in the supply business. We're in the distribution business. And if I'm not correct, there are federal laws that prohibit us from providing the information that Mr. Green is suggesting that we would provide to our affiliates. We're completely segregated from our affiliates by federal law. And we wouldn't do that in the first place. And I guess finally, we just need that information to be able to give the customers a good customer experience and to settle disputes.
Thank you, Mr. Kane. Any other utilities wish to speak on this topic?
Mr. Chairman,
Mr. Seegers?
can you hear it?
We try speaking again. We may have trouble with your audio now.
Can you hear me now, Your Honor?
Yes, yeah, we can. Please proceed.
Okay. Thank you very much, Your Honor. I would just like to echo everything that Mr. Trout and Mr. Kane just said, and I would like to make two additional points. As we discussed on Monday, there's concern by the suppliers sharing their commodity prices with the utility. We already established on Monday, the suppliers already do that. Under our supplier coordination tariffs, it specifically says that the utilities are only going to, the utilities will not purchase non-commodity charges or late fees. So in effect, we already know what the suppliers are charged for their commodity prices. And the second point is that, for lack of a better way to put it, I don't believe that the utilities have any interest in what the suppliers charge for their commodity prices or their non-commodity prices, for that matter. But even if we did, even if there was some desire for the utility to try and undercut a supplier, we don't have that ability, just because of the fact that we do not set the prices for our SOS products. Those prices are set by auction. We have no control over the bidding, and those prices are reviewed and approved by the commission. So I think those additional points further show how the suppliers' concerns are just on this issue are just unfounded, Your Honor.
Let's hear from the Office of People's Counsel.
Thank you, Mr. Chairman. Jake Alexander with the Maryland Office of People's Counsel. We support the position articulated by the utilities. We believe that they should be provided. As a basic proposition, we think that there should be, a symmetrical treatment of this issue when it comes to consolidated billing. So suppliers have, as I understand it, have this full bill view access to view the bills that the utilities are sending to customers that include their charges. And so as a basic proposition, we would expect that the rule would be mirrored on the supplier consolidated billing side. We also think that there are pragmatic reasons to support that. As mentioned by Mr. Trout earlier, we agree that utilities are frequently called upon to answer customer questions regarding consolidated bills. And, we believe that providing that bill view access to the utilities will facilitate that and lead to a better customer experience because, accurate information can be conveyed by the utilities to customers more quickly than would be the case if the utility had to say, you know what, we can't answer your question. We don't know. You're going to have to contact your supplier. And so for those reasons, we would, recommend that the commission, provide the same level of bill view access to utilities that suppliers enjoy currently under utility consolidated billing.
Thank you, Mr. Auslander. Just a logistical note, when we screen share, I cannot see all the stakeholders before the commission. I'm typically going to call upon the petitioners, the utilities, staff, and OPC. However, I recognize there are other stakeholders in this virtual hearing room. And if you have any comments, please interrupt and jump in. We'll turn to Commissioner questioning now. Mr. Green,
speaking of interrupting, Landon Farragut, MEA, just very briefly, I just wanted to state that we agree with the petitioners that full bill view access would probably only serve to provide unnecessary and potentially commercially sensitive information. I think this is another instance in which OPC and the utilities are guarding against a specter of pure charges or an assumption of a future impropriety on the part of the retail suppliers, and I don't think that there's really grounds to solidify those beliefs.
Great, thank you, Mr. Farragut. Mr. Green, a question for you. The utilities have stated a number of times that they do not plan to misuse any of this information. The utilities also stated that you have access to their bills now. It would only be helpful for them to address customer concerns if they had easy, accessible access to your utility bills. On one hand, suppliers are competing against the utility, but the utilities aren't necessarily competing against suppliers. How do you respond to the utilities' arguments that your claims are unfounded and perhaps over-exaggerated?
No, I would put it the other way. I think that their need to see our bills is exaggerated, and it's not an apples to apples comparison. First of all, I don't know how many suppliers actually use bill view access. Typically, from what I'm told, they don't use it all that much because the customers will just call and rattle off what's on their bill. But when a supplier looks at a utility bill, the utilities rates are public, they're regulated, and they're consistent by class. The supplier prices, or it's bill ready, right? So the only thing on the that the utility has is what the final price is, $75.42 or whatever it might be. Certainly they can back into whatever that price per kilowatt hour might be if they want to try. But that's all that they see right now. So it's not an apples to apples. You see our bills, we should see yours. That's not how this works. Second is that I don't understand the argument that they need it for the customer experience, because if the customer calls the utility today and asks, from what I'm told and from what we discussed in the working group process, utilities don't want to answer questions about supplier prices. And I would hope that the utilities would back me up on that. But that So if there's customer, even if they had access to our bills, they should not be answering questions about what's on our bills. So they don't need that. And they have, for the customer experience, they know what their charges were that they sent to the supplier, whether they have our bill or not. So they have that information. They know what the prices are, or what their rates are, and they can explain that to the customer. If the customer says, "Well, I paid that, it's not reflected. I don't understand why I owe what I owe," then the answer at that point is, "Well, you'll have to talk to with your supplier. They are your biller," and I think that's a reasonable approach to take. So, and then the last thing I'll just point out, since I'm rolling here, is that Mr. Trout stated that they need the bills in order to settle with PJM. PJM doesn't look at retail bills. That is absolutely inconsequential, doesn't relate at all. You do not need retail bills to settle with PJM. So I don't quite understand where he was going with that. But the bottom line is that they don't need this, in our view, and that providing it creates the incentive to data mine. And it is a very important issue to us, and we like the red lines we submitted, and we're sticking to them.
Chairman and commissioners, Washington Gas would like to respond by the fact that we need the bill view so that when customers do call about distribution charges being returned for non-payment, we can explain that, as well as disputes around payment once the accounts come back to the utility or move to another supplier. Without that, the utilities would be severely handicapped in doing that.
Okay, thank you, Mr. King.
If I may just respond to that, and I think Mr. Baker touched on that, and we certainly touched on it in our comments, is that, and we looked at regulations yesterday. The supplier is responsible for keeping accurate records of how they posted payments. And the utility has access to that information. And we're talking about when we're no longer serving the customer. They're not even our customer anymore. They've been dropped for non-payment. And I believe what Mr. Kane was referring to was that at that moment in time, when they are now a Washington Gas customer, Washington Gas wants to see, have the payments been posted correctly. We already have safeguards in place for reporting, and they would have access to those reports.
Mr. Green, before I turn to Commissioner Herman for questions and the other commissioners, I'm still having trouble seeing what your worst fear is with the utilities having access to this. Do you think they're going to use this information in violation of COMAR and other laws to take anti-competitive positions against the supplier? What is your worst fear in this case?
I think that's it. I mean, that is a definite worst fear, and whether we write it into the rules or not, and I'm not saying that they're doing this, it's just, it is competitively sensitive information, and we have to do what we can on our side to protect it. Even if a customer calls in today and says, and it has a question, and they pull the bill, the utility pulls the bill and says, "Oh, I see you're paying more with that supplier than you would had you been on SOS." I mean, that is arguably a marketing tactic that would be violative of the current COMAR.
It would be, and there would be serious consequences to any Maryland distribution utility that would abuse access to that information. Thank you for clarifying that. Did you have a final thought?
Right. No. So my point is that although that I'm sure is not an intentional violation of a COMAR, the mere access to all of this information in one place, intentional or unintentional, can lead to using it in a competitive manner that we're extremely sensitive to.
Thank you.
Mr. Chairman, this is Washington Gas again. We just want to also emphasize that we have this information under UCB, and again, we're not going to use this information in an improper manner. I mean, there are penalties that the utilities can face by using this information. We go through compliance on this issue usually annually. So we're not going to misuse this information. We already have it with UCB.
Mr. Chairman.
Mr. Trout, and then we're going to turn to commissioners. Mr. Trout.
Okay. I want to acknowledge the gravity of the concern that Mr. Green raises about utilities marketing standard offer service. I could see where that would be a very serious concern to anybody in the retail markets. And that is why when we wrote the rules for standard offer service in 2002, so almost 2 decades ago, we made it explicit that the utilities can't market in any way, shape, or form standard offer service. That's been in the regulations for as long as there has been standard offer service. I was one of the people that was involved in writing those rules at that time, and I know it's there. And no one in 20 years has said that I'm aware of has alleged that any utility has ever violated that rule. And as Mr. Kane points out, and we've had the theoretical capability of making price comparisons. That it's always been the other way around. The suppliers always want to make very, very explicit what our prices are. So nobody's ever said that we've been trying to talk down or talk about their prices. That's been the case for almost 20 years. Now they want to put in the rule again that we can't market standard offer service. So it'll be in at least 2 different places in the commission's regulations. Belt and suspenders, I'm fine with that. But it's a legitimate concern. It's a concern we talked about 20 years ago, that we built a safeguard against 20 years ago, and that for 20 years that safeguard has worked. So while I appreciate Mr. Green's concern, I think 20 years of success is a good validation for why their objection to this specific provision, which we see as being customer-centered, is misplaced.
Thank you. Commissioner Herman.
Mr. Chairman, Mr. Green, I just want to make sure, because I believe in your comments, it was suggested that supplier bills are proprietary in form and content. Do you maintain that as a position?
Look, are you asking whether they are
proprietary? I believe there were comments in this proceeding that said these are proprietary.
When they're sent from the supplier to the customer, whether that makes them confidential in a commission proceeding, if that's the question. I'm not sure.
Well, I mean, that's one of the arguments. I mean, you didn't make it today, but that was one of the arguments, and I had some serious questions about how a bill that gets sent out and a customer could post it on their Facebook page, and clearly bills, supplier bills, utility bills, the customer, once it gets to the customer, there's nothing proprietary to it, is there?
Because the customer can do what they want with it. That's up to them.
Right. So I think that argument, I just like to make sure that we address that argument, because I think that argument is challenging at best. So I have to say, your biggest concern is that they're going to market and they're going to data mine. Those are your 2 big concerns, right?
Those are, yes.
Okay. So are suppliers data mining when they get the utility bills?
I don't know how often suppliers even look. So we can look at the prices on the website. We can look in the tariff. We can look at the website being either the shopping website now and also the individual utilities websites. These the SOS prices are available in many areas.
So I guess what I'm saying is that it's equally possible right now for a supplier to data mine off of a utility bill, is it not?
I don't know why we would. I mean,
Well, okay, stop there. Stop, Mr. Green. Mr. Green, you said you don't know why we would. Why would utilities data mine? If suppliers aren't data mining, why would utilities data mine?
Right, because let's take a step back. I mean, if you're asking us, or do suppliers base their pricing on the SOS and cell service price? I think many do, many don't. Many have a value proposition that has nothing to do with the SOS or sales service because they offer something else as well. Others are a strict price-to-price comparison, and that's their value proposition, that they can offer you something lower than the SOS price. So that's a supplier by supplier basis. But that presumes that that an SOS or sales service is a competitive product that they go out and market, and they don't do that, and they can't do that. It's not set up that way. Whereas suppliers, 70 to 80% of customers remain on SOS and sales service. So that the way it's been set up is that is the price to compare. That's the biggest beast in the market, so to speak, the big gorilla.
Yeah. But data mining includes everything that's on the customer's bill, right? So the supplier could very easily, in the supplier as well as the utility with respect to data mining, I think, there's equal issues associated with data mining. Do these regulations in any way limit a supplier's ability to file a complaint if they believe a utility is marketing against their product?
No.
Okay. So I have to say that from my standpoint, I think that you've really made the argument for bill view access, Mr. Green, when you say that every supplier's bill is going to look different and everything's going to be very different. How is the utility representative? They're going to need to be able to help people out, particularly in the beginning of this process. If somebody gets a supplier consolidated bill, they're going to want to understand the utility charges as well as the supplier charges on that bill. And I think, at least to start out, that the utility should be able to see what their customer is, because it's still the utility customer. Utility is still providing a service to that customer. So in my view, I think that bill view access is necessary because bills will be so different, and it would be really helpful for the utility rep to be able to understand what the customer is looking at. And therefore they could say, well, no, on page 5 of your bill, you need to go talk to the supplier about that. If they don't have page 5, they're not going to know. So I really think that if the concern is simply that utilities will market against your product, I think there are sufficient remedies against that. And I believe that the utilities need bill view access. Thank you, Mr. Chairman.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Green, do your clients perceive the utilities to be a competitor?
I think on the whole, probably yes. Some suppliers, like I said, may not, because their value proposition is not against SOS. It's not necessarily based on price, but I think there are many suppliers that do.
But don't retail suppliers, or many retail suppliers, bid into the SOS market through a competitive process?
I mean, they may have affiliated entities that operate on the wholesale market in terms of bidding into SOS. I don't know if my understanding is that the retailers that I'm representing are retail entities. That's how they're set up. That's what they do.
I understand. My terminology may not be right, but many members of RESA are also bidders into the wholesale supply side of SOS. In fact, SOS has not much to do with the utility except as a pass-through in the distribution system, right?
That's how SOS is priced, yes.
Okay, so you're not, that SOS pricing is not utility competition with the retailer. It's the wholesaler who's the competition, who's passing it through the utility on their distribution lines to the customer.
It's a retail price with an admin charge on top of it. It's the wholesale price with the admin charge makes for the retail price, which is what we have to compete against. That's
Right,
how
but
the
it's
whole
not-
system was set up. It's a
it's not-
PTC on everyone's bill. It's on the websites. It's on it's everywhere you turn.
Mr.
That's what
Green.
we're competing against.
Mr. Green, my time to ask questions. So I know this sounds like it's getting argumentative, and I don't want it to. I want to understand your
apologize.
position, sir.
All right.
And this happens very often with you and I, and it's frustrating for me. I'm trying to probe your clients' positions. So if you view the utilities as a competitor, you're not really competing with them on price, because the price is only passed through with an administrative charge, albeit, got it, but you're not competing with them on price. What are you competing with them on?
We are competing with them on price, and we're competing with them and offering other durations of contracts and anything else that is customers may want that's within the bounds of what we can provide. And so I'm not sure. I'm not sure how else to answer your question. It's to suggest that
The utilities do not set the SOS price, do they? Let me put it that way. They do not. Clearly, they don't. They don't. The price
utilities go out to bid. And, right, they procure their power. They have an admin charge, and the commission approves or accepts, I believe, the new tariff rate.
It's a competitive bidding process overseen by the Maryland Public Service Commission. And the utilities have nothing to do with setting those prices. Nothing.
Correct. They bid it out. Right. You're right. We can agree on that.
So I want to establish that SOS, which is the boogeyman of competition for your clients, is not really the product of the utility. It's a pass-through. And you're competing with the wholesalers passing that through the utility, not with the utility with regard to pricing, price points, and price signaling. That's all I'm trying to establish here. Because when you say you don't want to show their bills to their biggest competitors, I'm trying to figure out why. Because you're not really competing on price with the utility. You're competing with the wholesale market price. And so I don't understand your fear here. I really don't.
The one way that I can answer that is that the retailers are also on the wholesale market every day, buying energy, trying to figure out the lowest cost and the lowest way to pass it through. And if you're on a price-to-price competition level with all others out there, which would include the SOS price, right, then however you can procure that procurement strategies and your costs goes into that, how you price your product. And I think it's respectful that the US is or sales service are not, that we're not competing against them, because this whole system since 1999 is set up so that we are competing against them every day.
I acknowledge that you're in the wholesale market as well, and I think that's a correct point. So in that regard, on the supply side, you are, but you're not doing it through a regulated forced competitive bidding process. You're negotiating your own contracts, and it's very different than the SOS process, which is a public overseen process that's formalized. And I fail to see. Yes, I understand you're buying into the market from the wholesalers, but you're not competing against the utility per se on price point. You're negotiating your own contracts. On the other hand, we have a publicly overseen bidding process. It's very competitive and very well regulated. So I'll just let it go at that. I fail to see your fear here, because it looks like it's taken care of by the provisions of C2. So thank you, Mr. Chairman.
Commissioner Lincoln.
Thank you, Mr. Chairman. I had a couple questions for the utility companies. I'm intrigued with the suggestion that has been raised a couple of times by the utility representatives that have spoken, where they've suggested that they will use access to this information to respond to consumers who call with questions. Am I to understand that you are going to respond to questions about the suppliers portion of the bill? This goes to any of the utilities that have already spoken this morning.
Mr. Commissioner Linton, sorry. Not as a first choice, no. But particularly if the supplier has sent the customer to us, or if the customer asks a question that requires us to address multiple parts of the bill, we will have to. We will have to have that ability, because otherwise where we are is in the position of just telling the customer, we don't know what you're talking about. We're very sorry. You have to call somebody else. And that's not the kind of statement that we want to be making to our customers, because they're still our customers for distribution service no matter what. And respectfully, Commissioner, I don't think that's the kind of statement you want us to have to make to customers if there's a reasonable way of avoiding it. So yeah, we would in the first instance, if it's the first inquiry and the customer is asking us about, well, why did the supplier charge me this? You're right. Our reaction would be, well, I don't know what you're talking about because I can't see it unless we have bill view access. But in any case, our reaction would be, well, we don't know why the supplier charged you, $10 there as opposed to $5. That you have to ask them. But we're talking about a scenario where the customer is asking a mixed question about multiple parts of the bill, or a scenario where the customer has come to us after having gone to the supplier and either been sent to us by the supplier or they've come to us on their own when they can't get an explanation from the supplier. That's what we need to be prepared to deal with. We get those situations now where customers ask those kinds of questions, or where customers have been to the supplier and have come back to us, and because we are the ones providing the bill when it's UCB, we at least have all the data in front of us. Sometimes we still can't answer the questions, but at least we're better able to answer it, and we don't have to say, I don't know what you're talking about because I can't see the bill. We really want to avoid that conversation. That will get ugly, and there will be repercussions, and there will be complaints to the commission, and everyone will be unhappy, including us.
So I understand the comparison to the current billing structure, and it's pretty much been that way. It evolved to what we have now from the very beginning, because there were a couple of basic standards that were there. Obviously the utilities didn't want to have any role in answering questions about the supplier commodity charges, and even to this day they still don't. They may know, you know what the number is, but you don't know how it actually got established. And if a customer has questions about that, you wouldn't be able to explain it. But you know what the bill amount that has been purchased by the utility is. It's been that way for a long time. So if we now move to a scenario as SCB envisions, where the supplier is purchasing the utility receivable, am I wrong in suggesting that it seems like the utilities are a little reluctant to let the supplier have more of a role in having that conversation with the customer?
No, Commissioner, I don't think that's the basis for the concern. But you've made I think for our arguments a good point, which is today under UCB, both the supplier and the utility, when they answer customer questions, have access to the full set of information that's on the bill, because we are the ones who prepare the bill, and then we give the supplier bill view access. And I'm was kind of perplexed to hear Mr. Green say that suppliers aren't using the bill view access, because why did we go to all the trouble of giving them bill view access and the expense of giving them bill view access if they don't use it? But nonetheless, they have it available to them, so that both the supplier and the utility, when they're talking to a customer, have full access to the same range of information about what's on the bill. And what the suppliers are talking about is creating an environment where, for customers that go to SCB, that no longer is true. The supplier will still have access to all of the information that's on the bill, but the utility will not. And in that respect, customers who switch to SCB would, under this paradigm proposed by the petitioners, would be worse off, because one of the two parties that they potentially have to talk to doesn't have all the information that they do in the current environment. So we view this as a step backwards from a system that has worked.
So that envisions then that suppliers would answer questions about the utilities distribution charges under SCB. I don't believe that happens. Does it? Does that currently happen now?
Under UCB, well, they're not supposed to, but again, the questions get, you've spent many years in your prior capacity dealing with customer complaints, and that customers can get things scrambled together, and part of the job of the people who deal with customer complaints is to unscramble things for them. And when everybody's working with the same full script of information, that's a lot easier to do than when one party has only a limited menu of data, and the other party has the full script. With respect to, I just wanted to add another point that relates to what you just raised, Commissioner, which is one of the things that the suppliers have been resisting in this proceeding, and we've either are going to debate it or have already debated it, and I was somehow not paying attention, is this: the suppliers don't want to put our phone number. They don't want to be required to give the customers our phone number, and they don't want to put it on the bill. And that just, again, it's going to make things worse. And customers aren't going to be as well off as they are now. And so I think having UCB be less functional, having SCB be less functional than UCB does a disservice to customers and is going to harm everyone involved, including but not limited to both the suppliers and the utilities.
So then the utilities are looking for this SCB, I guess we'll just for purposes of today, calling it electronic access, to be something that they can use on a when the customer calls moment. So at 10:14 on a Wednesday afternoon, the customer calls BGE with a question about their SCB bill, and the utility can now access that information, I guess, in real time or at that moment. Is that the way it's envisioned to work?
We're starting to push beyond the four corners of what I have direct personal knowledge of. If we have a subject matter expert on how the Customer Interactions Act, who's on the line and wants to step forward, that would be great. Otherwise, I will continue to wing it. And I have worked on customer issues, and I do work with the call center people, and I believe, but I am not sure that is what you just said is correct, that they can pull it up right then and there.
It's certainly checked. I'm not holding it to one way or the other. I'm trying to understand technically how you're envisioning this working. So All right, that would make sense then. So the suppliers have expressed some concern that the utilities may use the information to data mine some of the offers. And I think it's less, as we've had several, both commissioners and other members of the other parties here today note, I don't think it's a SOS issue as much as it is some of the bundled add-on types of services that may not be regulated by the commission, but that utilities may offer. So it may be, for example, something like a supplier that offers a Nest thermostat when a company sells Nest thermostats. And so there's a question of knowing what the supplier's price is. The utility offers the same product. And the question then becomes, will the utility, have a weekend sale and lower their price to beat the supplier's price? So I think that's what I'm hearing from the suppliers. So I guess my question for one of the utilities then, with that understanding as to what I believe the suppliers are concerned about, is that that detail, that type of information also necessary for utilities? Do you need to have all of that as well, access to that, or is there a lesser level of information that you could have that would allow you to still answer customer questions, but not get into those issues that suppliers find to be competitively sensitive?
The short answer is no, there isn't, and there are two reasons for that. The first is that in most or all circumstances that I'm familiar with, and I do not profess to know what every company in Maryland is doing, but in most circumstances, for most of the utilities, those kind of products are offered by affiliates, not directly by the utility. I'm most familiar with, from my prior client, with the distinction between BGE and BGE Home, for example. And we have had for a very long time rules that I know I was involved in writing. Commissioner Linton, you may have been involved in writing them. Commissioner Herman may have played a role in writing them. They've been in place for approaching 2 decades now. Affiliate rules that prohibit the utility from the regulated utility from passing information on to the unregulated affiliate, and those rules have. I'm aware of no complaints in all the time those rules have been out there. So there's strong protections. The other part of my answer, Commissioner, is if it's on the bill and the customer has the bill in front of them when they're calling us or calling the supplier. Right now, both we and the supplier can speak knowledgeably in response to the questions that the customer asks because we can see everything that's on the bill. So no matter what it is that's on the bill that they ask us about, we can at least see what they're talking about in order to frame our answer, even if our answer is, gosh, I have no idea why the supplier charged you that, but I see that it's there. And what the construct that's being proposed for SCB no longer would have the utility able to answer those questions in any meaningful way because we will not see what's on the bill.
Okay, thank you, Mr. Trout, for your answers. Thank you, Mr. Chairman. That's all I had.
Thank you.
Chairman,
Ed, hello?
Sorry, Mr. Chairman. It's, if I may just have a couple seconds to respond to that. It's, the natural paradigm of SCB is to develop a relationship with the customer. So the customer looks at the supplier as his or her supplier, and if there's an inquiry to be had, that's the first touch point. And so in response to Mr. Trout, it's okay for a utility to field a question about supplier charges by saying, I don't know. You should call your supplier. That's okay. And in fact, that's what the utility us do when we get questions about supplier charges. We were chided in the working group for even suggesting that we would train our customer sales reps to respond to utility questions. So what I heard from Mr. Trout was, we don't want to respond to questions about supplier charges, but we need the bill so we can respond to questions about supplier charges. And I think at the end of the day, if you look from the big picture of what is SCB trying to accomplish, why is it so important to the suppliers to participate in it, is to develop that relationship so that the supplier is the touch point for questions. And I'll leave it at that.
Chairman?
Yes, Commissioner.
If I could just have one extra follow-up from Mr. Green.
Yes, please.
Thank you, Mr. Chairman. Mr. Green, you've heard a little bit from the, I'm sure you've heard a lot more than we have this morning, from the utilities about the types of information and access they're looking for. What would it entail for a supplier to develop and offer that from a technical perspective? And Mr. Trout, subject to check, has acknowledged that this is more of a real-time type of access. And again, it's subject to check. But let's assume that that's the customer's on the phone and the utility wants access to that information at that moment. What would that entail for a supplier to do on their end in order to prepare for that work?
I'm sorry. I'm not sure I'm following the question, Commissioner. Can you rephrase that?
Sure. I'll ask it a different way. How much does it cost to do this for you?
In order to set up BillView access?
Yes.
Or I'm not aware of any estimates that have been performed.
Okay.
Technological standpoint.
Okay.
Commissioner Litton, may I?
I don't know who it is, sure.
This is Ben Baker with staff. I don't have a cost or anything for you, but when we were discussing this issue of how are you going to share information back and forth within the working group, there was a discussion of, is each supplier going to provide the utility a unique portal for them to access, or would there be one common housing? I think it'd be pretty optimistic to think that there could be one common housing. And so I think we are likely in this kind of a scenario going to be looking at the work group will have to work through this, but the way I would view it now is likely multiple portals that the utilities would have to go and access to get into the bills. Now, we could also be discussing possibly electronic transactions back and forth, but I don't know which of those two is a more cost prohibitive approach, and something as a work group we will need to work through depending upon what the commission's decision is on this issue.
Right. And Commissioner, if this is helpful, I know the working group discussed if a customer calls the supplier and has utility related questions, that there be some, what other jurisdictions have, like Texas and Alberta, is there is an email system or a portal set up where the supplier is the question and then is able to get back to the customer, probably not in real time, but maybe an hour or whatever, a day later, with the answer. And I think, and WGL can confirm this, I believe that in their SCB, semi-SCB system that they have now, they have a similar setup where the supplier can communicate by email or some electronic format with the utility to get answers to the questions and get back to the customer. I don't know if that's what you were asking or not, but I hope that's helpful.
It's helpful, and I appreciate it. Thank you, Mr. Baker and Mr. Green. Thanks, Mr. Chairman.
Thank you. I know Mr. Baker allotted 25 minutes or so for this discussion, and we've gone well over. It doesn't bode well for the rest of this agenda. At this point, I will ask for the commissioners to provide their informal guidance, although I have to suspect where some of the votes are already, beginning with Commissioner Richard.
Thank you, Mr. Chairman. After listening to the discussion, I think, again, this is a place where the staff got it right with the language they provided. I ultimately, I think, concerned about the customer experience, and I think it was described as someone getting ping-ponged around, particularly if they just had a simple question and it just happened to go to the wrong entity. So I like the language as it has been submitted. And I think it does provide, it re-emphasizes those protections that already exist for for the supplier. So with that, I would stand by the presented language.
Commissioner Herman?
Thank you. I think the utilities should have bill view access. I don't believe the staff's language provides bill view access. So I think that, in my view, they should have it. And if I understand Mr. Trout's concern with 2C, because it doesn't say share the bill. It says information from the supplier bill. But I think that can be fixed this afternoon. So I think that can be addressed without, I don't think that's what they intended, but I think that's what it says. So a careful review of the language can be fixed. And I don't have a problem saying again that they can't use the supplier information for marketing, but that is, so if people prefer that to say it again, I'm fine with that.
Mr. O'Donnell?
So from the perspective of price competitors, I don't think the SOS charge is a competitive force. If the competitive forces are other things like bundled offerings and other stuff, that's taken care of in C2, I believe. Commissioner Herman may have a good point with regard to the language, and I'm open to that change. I'm not hung up on the specific language, and I know how important that is. But the joint utilities, Potomac Edison, staff, and OPC, I think have gotten it right. There should be some reciprocity here because the utilities are not adjusting their SOS price in a competitive manner. They have nothing to do with it. And they're not competing on price for SOS, and there's a prohibition against marketing SOS. I just fail to see the concern here. I really do. So I support the staff's position.
Commissioner Linton?
I can see the benefits for having the utilities, allowing utilities to have access to the supplier's bill. Customers are going to have to contact utilities for a number of reasons, even after SCB is established. Concern that I have is that there is not in this language that we have currently in front of us, there's not a primary entity responsible for speaking with the customer about the bill. If the utility has access to everything and can answer all questions, but there's a problem the customer doesn't like, conceivably, the customer doesn't have to speak to the supplier at all, even though the supplier is the one handling the billing. So I think it would be an awkward situation, even for this commission to investigate, where a supplier has a complaint filed against it, or even multiple complaints filed against it, but the utility company is the one answering all the questions about the bill. So I think when I see something like this, it sounds more like a transitional issue, because at some point, the commission, in adopting these regulations, would have to be making the policy statement that supplier consolidated billing is something that the state is approving and moving forward with, which means that the supplier is the one you speak to about the bill. And so while I understand that I think there's some benefit to the utility having access to the information, and I was attempting to find out if that was a cost prohibitive issue or not, and it may still be, I don't know. But there needs to be a primary entity to answer questions about the bill, so that in the event there's questions about accuracy at a later point, you don't want to have both parties with all the information giving different answers to the customer. I think that can create the same kind of confusion and concern that we are concerned about here today by not giving utility information. You can create that same scenario by giving too much, to the point where they're both equal parties to a situation or a problem if it comes up. So I'm not opposed to the idea of, I think this language needs some work. I mean, I think there's some extra language that you would need here to make sure that it's clear that the supplier is the one that gets the questions first, and even second if necessary, before utility companies are answering questions about it. I don't think that we should have this imaginary tether between the distribution costs when they're being charged by the supplier's bill to the point where the utility can always answer questions about that portion, even when it's being billed by another party under our regulation. I think at some point, if the supplier is billing and they're responsible for it, they have to be responsible for it, good and bad. And if there's a problem, then it's their fault, and they're the ones responsible for getting it fixed. And if that means working with the utility or whatever, then so be it. As far as Section 2 goes, I think the majority of this is I agree with Mr. Trout that this is in other places in COMAR and in statute. But if it was good enough to say once, we can say it twice. So I guess it's nothing wrong with leaving it there.
Thank you. With respect to the question of utility bill access, I support the staff's position. I found the petitioner's arguments unavailing and based on the premise that the utilities would misbehave, and there's no indication that the utilities will, especially in light of existing regulation and law. Similar to Commissioner Linton, I do agree that C2 is belts and suspenders, but I could live with it remaining in COMAR. Although I do agree with Potomac Edison that the highlighted language regarding non-governmental entities should be struck. I would ask for clarity with respect to C2. I had some trouble earlier. I do have a proposal if the host advisor could make a change for the consideration of my colleagues. So it would state a utility with access to a customer's supplier consolidated billing information, including supplier charges, may not. I think that reads simpler and is in plain English. Any objection to that proposed edit? Thank you, Ms. Knoll. At this time, we will take a lunch recess until 1:10 p.m. this afternoon.
Mr. Chairman, may I ask a couple clarifying questions, please?
Recess, yes, Mr. Baker.
Yeah, thank you. Staff's position on this had actually been more in line with the petitioners. So I believe what the commissioners were, I would like to just clarify, when the commissioners were saying they support staff's position, were you supporting the position that the supplier will only give the utility information related to utility charges and messaging, or are you saying give the utility the entire bill? And we'll make that clear in C1, however you'd like to go, but I just wanted to clarify our position was in line with the petitioners.
Thanks, Mr. Baker, for clarifying. My position is that the utility should receive the entire bill, and we should hear from the commissioners on that point.
I'm kind of shocked to hear that the staff had the same position as the suppliers. I'm shocked. And I think there should be reciprocity. So if that's not what staff was saying, wow.
I was just referring to the language before us, and I thought that was the staff position. I thought that was the default position, but I think I'll be okay with Commissioner Herman's suggestion that we go from information to bill view. So I'm fine with that change. But just to be clear, what we're looking at is what I'm supporting with the 2 or the 3 modifications. One from the chairman, one Commissioner Herman going to bill view, and then the other was the change to 2C.
And to be clear, that is my position. What we're looking at on the red line with the edits is what I support.
I want to be clear. I support bill view access. The supplier needs to send the utility what the bill looks like. This language, in my view, does not say that. And so I support bill view access, which is what the utilities and OPC support. So Just to be clear, I think I said this before, this language doesn't do that, but that's what I support.
So, Mr. Chairman, just to be clear, I also am comfortable with the idea of bill view access, but I think that, and perhaps with the commissioner's indulgence, I would ask the parties to, and I could even draft it if you need me to, but some language that suggests that the supplier is the entity that answers questions first, or is the primary entity to answer questions about the bill, as opposed to it being the utility. I think that you can run into a number, as I said earlier, I think you can run into a number of issues regarding who's responsible for providing information to the customer, if that's not made clear somewhere. And it's something we've done in other parts of our regulations for other issues.
I am confident your colleagues will provide you with that indulgence for that additional language. However, for the purposes of answering Mr. Baker here, we do have a majority for full bill view access of supplier bills to the utility. I recognize that this rulemaking session, more than others, is rather, with so many issues, is becoming rather frustrating for all parties involved on both sides of the bench. Mr. Baker, anything else before lunch?
No, thank you very much for the clarification. We'll make sure to do that.
Thank you. We are in recess. Let's move to 120 this afternoon, and then we'll pick up on the next topic. Thank you. We're in recess. We'll be back on the record in 1 minute. Going on the record.
You're on the record, Your Honor.
Ms. Knoll, if you could take down the screen share for a moment. I recognize that the parties have been working hard over the past year on developing these various proposed regulations for the Commission's consideration. Obviously, it's been a heavy lift. As I noted this morning, however, it would have been more productive had particularly the petitioners sought out the advice and input of the Commission throughout the course of the one-year work group proceeding. We have a lot of information before us. We're not making particularly good time in going through the voluminous number of proposed regulations before us. I've made the decision to conclude today's rulemaking after this afternoon session, and we will not be meeting on Thursday or Friday. This will allow the parties additional time to work on any areas of disagreement. It'll allow workgroup members to further refine the proposed regulations based on the advice that has been given by the commissioners over the course of the past 3 days. I recognize that there are a number of other issues where the parties are seeking commissioners' input, and we will try to get that to you this afternoon so that your additional discussions can be fruitful. Mr. Green, you did not formally ask for more time, but I get the sense that that was the position of the petitioners. Regardless, you will now have some more time, and we will continue this rulemaking session until sometime in January, after we could figure out some dates that work for all the parties involved. However, we will make use of the next hour and a half up until 3 p.m. to address any remaining issues. And I will leave it to Mr. Baker to walk us through the next set of issues.
Thank you, Mr. Chairman. I'm going to petition that we proceed to the discussion of energy assistance next, since that is an area of significant disagreement between staff and the rest of the work group members. So guidance there would help us either edit regulations or remove regulations depending upon the commissioner's position.
Please proceed.
Thank you. Thank you, Mr. Chairman and Commissioners. Benjamin Baker on behalf of staff. So through this process of developing proposed regulations, one of the groups of customers that we have been focusing on as a team was how do we deal with customers receiving energy assistance within the supplier consolidated billing program. The work group spent considerable time and effort on this and has developed tentative process rules, but both staff and the work group acknowledge that additional work on those business processes are necessary. Staff has been of the position that when we go live in 2023, energy assistance customers should be able to participate in the supplier consolidated billing markets. A number of parties oppose this position, believing additional time is necessary to first see how the markets roll out and before we implement energy assistance within the supplier consolidated billing markets. With the commission passing or supporting potential eligibility requirements, this does open the door for the potential to restrict energy assistance customers from participating in supplier consolidated billing from the start, until such time as the commission believes that we should include them. Staff is still of the opinion that including these customers in the beginning of supplier consolidated billing is appropriate. These customers, so long as they do not have an arrearage older than 30 days, or if they are not on a payment posting system, will have done nothing to, they would be effectively good payment customers, and we don't believe it would be appropriate to restrict these types of customers from taking advantage of supplier consolidated billing from the beginning of the program. We believe the proposed regulations in front of the commission provide a framework around which we would continue to develop the program over the next couple months to implement supplier consolidated billing, including energy assistance customers. Other parties, which you will hear from shortly, believe that these customers should not be included in that additional time, that we should enter into a phase 2, and that after the markets have been established, that we would build rules and processes to include them within the program. With that, staff is available for questions. Oh, and I should also note that if the commissioners would like to hear the process of how we envision energy assistance customers being treated within the SCB markets, I do have Michael Zhang available, who can describe that and identify areas that have not yet been developed. But I also recognize that the eligibility issue might trump that first.
Thank you, Mr. Baker. And I might suggest to my colleagues that to make the most use out of the remaining hour and a half, we provide you and the interested stakeholders with more policy advice than necessarily editing red line language. Mr. Baker, you said some of the parties oppose your position. Are there any other parties that support staff's position?
Your Honor, Washington Gas supports doing a phase 1 with energy assistance customers. It would be cheaper for our IT process if we were to include them in the beginning of the SCB stage, rather than doing it on the back end.
Thank you, Mr. Kane. Is there any other party that supports staff's position? Okay, we'll turn to other parties, although based on what I've reviewed with staff's position, I disagree with staff's approach and believe that SCB should be launched without the additional complexity of having energy assistance customers at the outset. I believe that this issue can be addressed in phase 2. Would the petitioners like to speak next?
Your Honor, I don't have much to add except that our comments speak for themselves, and we support having this as a phase 2. You know, historically, it is not the supplier's position to keep customers away from choice or away from all options. But given the sensitivities surrounding this particular subset of customers, we want to make sure that SCB is rolled out properly and any kinks in the program get addressed before it's opened up to energy assistance customers. And I would also add that, I think one thing we've seen there was a subgroup to deal specifically with energy assistance. One thing that we saw is that the utilities do things a little differently as well, as far as dealing with energy assistance payments and so forth. So technologically, we can do whatever we need to do from the supplier side to accommodate, but we really think that, again, given the sensitivities, we think a phase 2 is the appropriate way to go.
We'll hear from the utilities now.
I guess I'm going first. On this issue, Potomac Edison is in full accord with Mr. Green and his clients for the reasons that he stated and for the reasons that you explained in your initial remarks, Mr. Chairman.
Thank you. And when I said all utilities, I did not mean to include Washington Gas Light. The Exelon utilities, anything to add? I'll take that as a no. Office of People's Counsel.
Thank you, Mr. Chairman. I'll just briefly echo Mr. Green's concerns. The work group did form a special subgroup to try to tackle this issue, but we really just ran into problem after problem, and most of it based on the fact that we still hadn't resolved some core issues and how just SCB would work in general. So we actually didn't comment on most of the energy assistance related regulations because we just believed that additional work was needed. So we share the near consensus view that that energy assistance should be left for a later date.
Thank you. Any other parties or stakeholders wish to comment on this topic? Commissioner comment or questions? Or positions?
I think it should wait until a phase 2.
Yeah, I agree wholeheartedly with a phase 2 approach, and I would just also say on this particular in this area of energy assistance, consensus will be important. Other areas are not. I'd like to see us hopefully move forward with an effective program to on supplier consolidated billing, but for this particular group, consensus, particularly hearing from OPC, will be important.
Hesitant that I am to disagree with both OPC and the petitioners when they agree on a topic. I'm more supportive of the staff and WGL approach. I understand that there's some concern about there's a number of challenges that need to be addressed, but that exists throughout SCB. I would caution the parties in trying to equate low-income customers with credit challenge customers or ones that would be filtered out because they're not making monthly payments. I think that's a poor way of looking at the low-income customers who, in some cases, may just have limited income, but are still able to manage their accounts properly and just happen to be able to be eligible for energy assistance at the same time. Secondly, I'd also note that the statute, the DREG statute, was specifically designed to make sure that low-income eligible customers were able to participate in choice. And there's a lot of just structure in terms of how it was designed was specifically for that purpose. That's actually why EUSP was created. So I understand that over the years, the money has been used and spent in different ways, but historically, that was the purpose of it, was to make sure low-income customers could participate in the program. So I think that if there's some hard work that needs to be done, the regulations were not projected to be put in place until 2023. So, that's just under 3 years worth of time. And I think there's still plenty of time to work on it to try and make sure it's done properly, and low-income customers can participate at the outset.
I agree with the petitioners and the utilities and OPC for a lot of reasons, not the least of which are the sensitivities that Mr. Green alluded to surrounding this subset of customers in the media, in the legislature, amongst certain advocates, where the whole notion and big picture concept of retail competition has been brought into question, and I think we got to get this right. It may not be apparent, but we want supplier consolidated billing to be successful. And for not the least of which is because of the law and because we've already indicated we're heading down this path, but we got the time to get it right. And I think a phase 2 is the best way. We're going to have knocking of some edges off of supplier consolidated billing because it's such a paradigm shift. Not elsewhere maybe, but in Maryland for sure. And these last 3 days have been evidence of that. But we can do this. We can get it right. We will get it right, and hopefully it will be successful. But I think phase 2 is the best place to deal with this subset of customers. So for all those reasons, Mr. Chairman, that's kind of where I'm residing right now in my thoughts.
Thank you. The commission has provided a majority view on the topic of energy assistance. Mr. Baker.
Thank you, Mr. Chairman. The next subject I would like to address is actually one we were going to cover tomorrow afternoon, and this would be the issue of cancel rebill. I'm aware that I believe it was the Joint Exelon Utilities and Potomac Edison and the petitioners all supplied comments on this. If they are willing to discuss this subject today, I believe this would be a good one for us to receive commission guidance on now.
Are those stakeholders in a position to discuss this issue today?
Your Honor, speaking for joint utilities, yes, I believe we can proceed.
Okay. Mr. Seegers, please proceed.
Mr. Chairman, sorry, go ahead, Mr. Seegers.
No, I was going to defer to you, Ben. Go ahead.
Thank you. The issue of cancel rebill. So the issue I would like to discuss with the commissioners today and receive your guidance upon is the how to treat a cancel rebill when the utility issues a cancel rebill. So not when a supplier issues the cancel rebill, but when the utility issues the cancel rebill because they discovered an error on their part. Staff's proposal is that if a cancel rebill occurs, that the utility should be responsible for billing the customer for all previous charges except for the current supplier's charges. This is because this would ensure that a customer would, in a cancel rebill situation on SCB, would only at most receive 2 bills and would limit them from receiving multiple bills for all previous supplier consolidated billers at no fault of their own, except for in situations of theft of service. The utilities pose this proposal because they believe, I believe there are technical implementation issues that I will let Matt or his team, or Mr. Seegers and his team discuss. Also today, under utility consolidated billing with dual billing, the approach they take is anyone who previously billed the customer, they will bill for their charges and at that time. That's our position, and we are available for questions.
Mr. Baker, perhaps it would help at least me for you to walk us through an example of a cancel rebill in light of your position.
Yes.
Customer, how would it work for me as a customer?
Yes. Ms. Knoll, could you pull up the business process flow documents? I actually included one for staff's position and one for the Exelon, or the Joint Exelon Utilities position. But starting from a high level, what would happen is the utility would realize that there is a mistake on their system, and they would have to issue they would try and recollect from that customer charges. They would, from the customer's perspective, from our position, the customer would receive a bill from the utility for all charges that occurred previously from previous suppliers up until the date of switch to the current supplier. And the current supplier would bill for their charges and the utility charges after that date of switch.
And let's get the chart up here, Mr. Baker, so you could walk us through, and if you could describe what number we're looking at.
Yes. Starting in box 2, that's when the utility would determine that there was an issue with meter readings. or if there were other problems with the bill, or this could also be in cases of theft of service. If the issue was less than 3 years old for an underbilling, I believe it's, let me rephrase this, anything less than a year old for underbilling, the utility is able to pursue without commission permission. And anything older than that, they will need to come to the commission for permission. So once they determine, and at that point, the utility will determine which suppliers that customer had. And this is in box 4. And then they will send electronic transactions to these suppliers and say, that is basically stating, we need to issue a cancel rebill. Here's the information you need in order for us to place their charges on our bill. And so the previous supplier will receive that information, and the current supplier as well. And they will send that information back to the utility. And staff is envisioning that the utility would be purchasing the supplier's charges at this point. And under a supplier consolidated billing perspective, this could include other items. The utility bill would then send those bills to the customer and so this is now, let's go to box 10. There's 2 things that will happen. For all charges that occurred before the current supplier took over, the utility would send that bill to the customer, and that's what's happening up in box 11, and the customer will receive that bill and will pay the utility. For everything that happened after the date of switch, the supplier will receive that bill, or so that the supplier will send the bill to the customer and collect those charges if necessary. And so this, basically what this is doing is ensuring, and the reason staff prefers this approach is this is limiting the customer from receiving from more than 2 bills over time, because especially for electric, the customer over a year could have multiple supplier consolidated billers, and they would be receiving an individual bill from each of them under the utility's proposal that they would then have to pay. And so staff thinks that would be a poor customer experience and believes that this would be a better approach. I can also walk you through the other position, though, of how it would work for a customer with a similar process flow on the next page.
That would be helpful to me, Mr. Baker.
Okay. And Mr. Seegers, if you or one of your technical experts disagree with a characterization at any point, please interrupt me. So boxes 1 through 4 are generically the same. The utility is going to determine that there is a cancel rebill issue or an issue with an under collection, and they will need to identify the appropriate suppliers. And then in box 5, they will send the cancel rebill information to the current supplier for them to be able to bill. And then in box 8, they will go each of those suppliers.
Mr. Baker, we've lost your audio.
Sorry, I might be having I'll put off my video in case I have bandwidth issues. What box did I lose you at? Box 8 or box 5?
Box 8. Okay,
box 8 is when the supplier will when the utility will contact all the previous suppliers, so not the current supplier, previous suppliers, and send each of them a cancel rebill notice and all the information they need in order to send that customer a cancel rebill. At that point, those suppliers will go through the process of rebilling the customer, and this would be both current and previous suppliers, and follow all the processes that we have been discussing so far this week, including the utility eventually repurchasing those. And at that point, so basically that's what's going to occur from boxes 11 to 14. And so I would basically say from a customer's perspective, the main difference is the number of bills they could receive for a cancel rebill.
And your concern, Mr. Baker, is that we may have utility customers who over the course of the year had, let's say, 3 different electricity suppliers, so they would receive 3 different bills from the suppliers?
Correct. And that would not be a worst case would be you have a customer choosing a new supplier every month. That's obviously maybe a bit aggressive of a thought pattern on my behalf, but yes, there'd be no limit in that regard.
Okay. Thank you. Let's hear from Mr. Seegers now in support of his position.
Thank you very much, Mr. Chairman. Can you hear me and see me as well now?
For the time being, yes.
All right.
Has improved your quality.
Thank you very much. As Mr. Baker indicated, what the position of the joint utilities is that under SCB, a cancel rebill that results in the undercharge to a customer should be done in the same manner that it is done under under UCB or dual billing, in the sense that it is for example, the better example is dual billing, Your Honor, where under that scenario, a customer, they receive a bill from their supplier and they receive a bill from their utility. If that customer had several suppliers and the cancel rebill time period covered those multiple suppliers, the customer would get a bill from each of those customers. That's how it's done right now. The challenge about requiring a utility to rebill prior charges is, first of all, we will not have access to prior supplier charges. Under SCB, the way it will work is that the utility is going to send its distribution information to the suppliers, but we will not have access to supplier charges. And second of all, it will put utilities in the position of possibly having to purchase supplier commodity charges, which could also include non-commodity charges. So that is why our primary position is that that any cancel rebills should be done in the same manner as it's done as it currently is under UCB or dual billing. And we're available if you have any questions, Your Honor.
Thank you. Do other stakeholders wish to opine on this topic? Commissioners, do you have questions?
Mr. Chairman, just one question, just to make sure I understand. Is this, and this could be for either utility or staff, we're talking about customers who, not a customer who has selected a supplier and then the utility discovers that the customer has an outstanding charge that hasn't been paid. Are those the customers we're talking about? Are we talking about customers who have selected a supplier, have a debt, and then have moved on to another supplier?
We are talking about this would apply to your second scenario. So the customer is on supplier consolidated billing, and then a utility identifies a bad meter read, or maybe they didn't send a charge, or I don't know what causes all the cancel rebills we run across. But basically there's a need for a reissuance of the bill. And so this could occur for a time frame when the customer has only had the current supplier. This could also occur in scenarios where the customer is with the utility or a supplier, this could also occur with the utility with the customer being with the utility, but they had supplier consolidated billing before that. And so what would happen here under the utility position is the customer would receive bills from each of its previous bill providers, while under staff's position, they would only receive a bill from the utility and its current bill provider if that current bill provider is not the utility.
And Commissioner, I believe that Mr. Baker accurately characterized that. Unfortunately, there are many reasons why a customer's bill may be needed to be canceled and reissued. But we're not talking about customers with arrearages, Your Honor.
So these are situations where there's been, and correct me if I'm wrong, please, but these are situations where the customer has been paying a bill, but there's been an error on the calculation of the bill.
Yes, that would be one example.
Okay. So when we talk about cancel and rebill, we're not talking about canceling the existing supplier contract of any way, but we're talking about just canceling the bill that's been issued or I guess purchased by the supplier that is now going to be transferred or billed to the customer.
That's correct, Your Honor. I think by way of example, let's say a customer gets a bill from January, February, and March, but in April, there's discovered that there was a billing error for whatever reason. So what the utility will do is that they will cancel those 3 prior bills and then issue a multi-month bill that covers from January, February, March, and April in the next billing cycle, if that helps.
And Commissioner, another, not an example, but just to a corollary to what the utilities have today for this would be in COMAR for what is titled adjustment of bills in 2050-04-05, which basically dictates all the different ways a utility can issue a bill adjustment. So maybe cancel rebill is the jargon we've been using, but maybe another way to think of this as we need to adjust the bill for various reasons.
Okay.
What was previously said.
Yeah, and so the language might be it's a semantic correction, but because I understand why you're calling it cancel rebill, but in COMAR it is referred to as an adjustment. So that's kind of I think that's what was throwing me off for a second. I wanted to make sure that I understand what we were canceling as opposed to adjusting. Okay, thank you very much. I appreciate it.
Mr. Baker, what's your response to Mr. Seeger's? What I thought Mr. Seeger said was that they may not have the right information for the rebill. You know, they don't know what the charge is, what the commodity charge is, if it's 6 months old or something like that. So how do you address that in your process?
Sorry, am I talking now? Am I coming through now better?
Yes, thank you.
My apologies. We address, so yes, in our proposed rules, we address 2 different scenarios. One, when the adjustment has to be made because of the supplier. So if the supplier had the wrong, was billing the customer inappropriately for their charges, then they would issue a bill adjustment. But in a scenario where the utility needs to reissue it, and this would be in boxes, I guess, Ms. Knoll, would you mind scrolling up back to the staff position? So what would happen is in boxes 5 and 6, the utility is going to send they're going to basically say, here's the usage. Let's say it was a bad meter read. We need to reissue our bills because of over this time period, we misread the meters and we need to send an adjustment to the bill for that. They would send that new meter reading information to the suppliers. The suppliers would calculate their own charges and what they should have billed the customer. And then they would send that to the utility to then bill the customer. So the utility wouldn't need to know the supplier's information. They would just need to be provided it.
Okay, all right, so that's a new EDI transaction that would have to be designed.
Correct.
Okay, and Mr. Seeger, so now you know it. So now we've addressed that problem. What was the other problem?
I guess the other problem, and maybe we misunderstood staff's proposal, but it sounded like that suppliers would sell back any undercharge for their commodity service back to the utility. First of all, I don't believe our IT systems would be equipped to do that, to accommodate a commodity charge. And secondly, that charge from the supplier could also include non-commodity charges. That's one of the big positions of the suppliers have taken in this proceeding, is that they want to bundle their charges. And if they do that, the utilities have no way of knowing if there's a commodity charge or a non-commodity charge in there. And that would put the utilities in the position of having to purchase non-commodity charges. Moreover, in the commission's order, I think the commission was rather clear that utilities, if we're going to repurchase anything, should only be in the position where we have to repurchase distribution arrearages. So it would be very hard for the utilities to predict how much of a commodity charge we would have to repurchase.
Okay. I think some of those things are doable, because if you're sending an EDI transaction, then that EDI transaction could be charged that it's only commodities that come back and that no non-commodities can be billed, and that the supplier would be on their own to bill a non-commodity. But I appreciate staff's desire to have only 2 bills. And I know there's, based on my experience, there's a lot more cancel rebills than we think there are in this, in the utility world. It happens all the time, unfortunately. Sometimes, things just happen, and sometimes they're for 7 years, and sometimes they're for 7 months, and sometimes they're for 7 days. So this, while it seems like a trivial matter, there's quite a lot of this happening. So it's hard for me to provide guidance. I'd like for, it seems to me that it's possible to work out some of the issues that we've just worked out. So that's about all I have right now, Mr. Baker.
Thank you.
Let me ask Mr. Seegers or any other person from utilities, from your perspective, how often does this happen where you resolve it and it's under retail competition right now with utility consolidated billing? How often do you have to do this?
Your Honor, I will have to defer to my subject matter experts on that. I will say that unfortunately it happens more than we would like, but I will defer to the PHI and BGE subject matter experts who might be able to give you some more definite numbers.
Commissioner, this is Robert Kane from Washington Gas. We actually have, I guess, a subject matter expert who could probably address your question, Batya Tacoin.
Okay.
Can you hear me?
I can't hear anybody.
Can you hear me?
Barely.
My apologies. Mr. Commissioner, what I was alluding to is one of the biggest issues that we'll have in this kind of respect is when we cancel a bill, and create a brand new bill, there would be the application of applying the customer's payments to the newly created bill without having knowledge of how that payment was allocated between commodity, non-commodity items and the split that we've been talking about throughout these sessions. We wouldn't be able to create a new bill with the correct payment amount applied for current customers' balance in the newly created bills.
I guess what I'm wrestling with is if this happens all the time, and we do have suppliers, multiple suppliers, I'm sure in some instances, who have to send the commodity information back to the utility for rebuild, I think that occurs right now under this process. I'm trying to figure out why it wouldn't work under supplier consolidated billing. If they're sending you only the commodity information, it'll happen just the same way it does now, right?
Commissioner Donaker, can I address this? Michael Sergeyev, DECA Energy.
Anybody can help me understand that. I appreciate it.
So the problem that we see with the staff position is that not all suppliers will be set up in the system to provide commodity charges to the utility, because those are different processes during the setting up on the system. Either you could be UCB and SCB, but for example, we're set up as SCB only. And for us to become UCB and supply some information to the utility that we're not providing now, it changes the whole setup originally when we go through it. So that is just when utility provides billing, it's easier for them since they are already on UCB and they can change from one supplier, let's say, to another, but they are the only entity that issues the bill. But here you have entities that are never set up for UCB. How are they going to provide this information? And will the utility understand this information if that supplier was never set up for UCB in the first place?
Well, I appreciate that. If that's so, I think this can be solved. I tend to agree with Commissioner Herman. I think it's solvable. It's just a matter of figuring out how the information flows and what information flows. Let me go back to Mr. Baker. On block 3 of your process.
Yes, give me 1 minute to pull up the document on my side. Yes.
I want to clarify something. I thought I heard you say it. I think you said something about if it's less than a year on underbilling, they don't have to come back to the commission, but anything over a year they do. But all I see in that block is a reference to 3 years of underbilling.
Sorry.
Can you clarify that for me, please?
I believe it is a year, and that's a typo, but let me pull up the adjustment of bill rules, because we tried to basically mirror as much as we could out of the current rules for utilities and the adjustment of bills.
Okay, if it's just a typo, that's fine. I don't need further explanation. If it's something other that is more complicated with regard to process, then I understand.
It's I now see what so if it's more than 12 months but it's less than 3 years, they can come and discuss it with you and get at least that's how I'm reading the rule right now. But the more than 12 months but no more than 3 years before discovery of the error. So that's when they would come and discuss the request to issue a rebill.
Okay, so what happens in a scenario over 3 years?
This is where I would defer to Mr. Seegers or Ms. Garofalo, but my hunch is they wouldn't be able to do it, or they could still petition you, but there's no rules about that that I'm aware of.
Commissioner, unfortunately, I don't have the rule in front of me. I do believe that Mr. Baker is correct that the utility can rebill anything under 12 months of charges without commission approval. If we want to go over that and bill in excess of 12 months, then we need to get commission approval. But I believe the regulation says that even then, I don't think we can rebill more than 3 years worth. I know the only exception to that is in a case of theft of service, but that is obviously not what we are talking about here, Your Honor.
Back to my question, what happens in that case where it is more than 3 years? Who eats those uncollectibles?
I believe the utility would, unless you're asking, I mean, that's in terms of what's the supplier's reciprocity in this issue?
Yes.
That's a good question that I don't think we have discussed. If it's the supplier's fault, they would fall under these rules that we have today for 3 years. If it's not the supplier's fault and the utility's fault, we did not discuss this idea of how we could take this back with the time we have. The issue of is the supplier also out of luck because of that, or can they seek reciprocity because it was not their fault? We did not discuss that exact concern.
Fair enough. You can kick that around in the expanded time frame. I'd appreciate it. Thank you. Thank you, Mr. Chairman.
Any additional questions or thoughts on this item? I was more sympathetic to the utilities' overall position rather than staff's. It appears that there is a degree of complexity that's involved here, which, in light of staff's position that we would improve the customer experience by reducing the number of bills, I understand that as well. But based on everything that I've heard, and I think you will take the other commissioners' recommendations into account to spend some time with this issue over the coming weeks and perhaps bring it back to the commission. But at this time, I'm more sympathetic to the argument I heard articulated by PHI. Any other thoughts on this topic?
So, Mr. Chairman, I would agree with Commissioner Herman. I think that that the utilities and the staff can talk this through some more. Parties are correct that these bill adjustments happen all the time. Normally when the customer is billed by the utility, it's not something that tends to be an issue. And oftentimes it could be for a very small amount of money. When there are errors, though, the utility is typically not able to collect when it's over 3 years. So we shouldn't see that part of the flow chart shouldn't have too many other challenges to it. So I think if the parties can talk this out some more, I think there's a middle ground in here where we don't have a lot of bills going to customers and the utility is able to collect the money that it's owed.
All right, Mr. Baker, the next topic.
Thank you, commissioners. 1 minute, please. The next topic I would like to call forward if the petitioners and other suppliers who submitted comments on call centers are ready to discuss it, but I would like to discuss the issues of call centers, starting with the requirement that the call center has to be Maryland specific. And then we can discuss the call center agents, which would, I think, also possibly include some comments from the utilities and OPC. Okay. So part of the commission's order implementing SCB required the suppliers to provide enhanced customer service and protections to customers. And one of those areas that we have focused on for this within the work group was mandatory requirements for call centers. We have put forward proposed call center reporting metrics that the suppliers would have to report to the commission at specific intervals that mirror closely what the utilities have to do today, minus some obligations for things that are related more to the service of the, I guess, the distribution service, and less about their ability to contact the utility. Staff has proposed that those call centers, though, report so that we understand how they're serving Maryland customers, that we have proposed
Baker, we lost you.
I'm back. Okay, thank you. So staff has proposed that those call center metrics be Maryland specific, which would require the suppliers either to have Maryland specific call centers or numbers related more numbers related to Maryland, so that they can track that information to be Maryland specific. Staff believes this will help the commission understand how the suppliers are treating the Maryland customers, and tracking that enhanced customer experience that we are expecting from suppliers. The suppliers oppose this requirement. They do not oppose reporting call center. They do not oppose the metrics, or maybe not all of them, but they do oppose this requirement that it be reported Maryland specific. They believe it would be costly and technically hard to implement, and believe it to be unnecessary. And I will let Mr. Green and other suppliers speak more to that. But staff still believes our position is appropriate, so that we can track the supplier, the enhanced customer experience under SCB. Thank you.
Mr. Green?
Yes, very quickly on the Maryland specific call center reporting. We addressed this in our December comments at page 33 and offered some red lines. The bottom line was that reporting Maryland specific requirements would require many of the suppliers, my clients included, to reprogram. It would require additional expense. Or a totally separate phone number, which right now the suppliers, typically the way they operate is that all calls feed into the same call center. And so what we proposed, what we learned actually after the working group, when we were preparing the comments, was that Illinois actually had the same discussion at the Illinois Commerce Commission, and we proposed red lines that unless you're already to paraphrase them, unless you're already tracking Maryland specific calls, you don't have to do that. Those are our comments.
Any other parties wish to provide feedback? I understand the position of commission staff in determining the quality of suppliers in responding to Maryland customers. Although I do see this as a overreach because the utilities, the suppliers, not the utilities, will likely need to undertake some additional amount of expense in order to properly tag and track Maryland specific customers when they're likely receiving calls from these suppliers' customers over a number of states. And for those reasons, I favor the petitioner's position.
I can chime in at this point too. I agree with the chairman's position. And I mean, ultimately, these are competitive suppliers. They are going to rise or fall, based on their performance. And unlike your monopoly utility, you can't walk away from the monopoly utility, but supplier customers can. So this is an area I think you described it as an overreach. I agree with that characterization. So I concur with the supplier.
I'd be interested in hearing Commissioner Linton's thoughts on this, as many of these initial contacts and call center quality will ultimately result in a complaint with the commission. So I don't know if you have anything on that, Commissioner Linton, but your background may inform me.
I was still noodling this one a bit.
Sorry.
No, that's fine. That's fine. I'm in the middle on this one. I think we're expecting a certain amount of responsiveness from suppliers. And we certainly want customers to have a positive experience. But at the same time, if suppliers are not providing that experience, then, as long as their contract allows it, customers are going to move away from that supplier and go somewhere else. So I think as an initial position, I'd be willing to support the petitioner's position, because I think if we get a lot of complaints, it will call for metrics, and we'll be able to proceed with creating them at that point.
Thank you for that. That's very helpful.
I tend to agree with the chairman. I think that this is a little bit of a reach, and if a supplier has a national call center, they have a national call center and they have to answer all these calls within this time frame or report on the calls that they answered within this time frame. And if they're not answering them, then we would know that. So I don't think it really has to be special routing for Maryland customers. I mean, part of this is if they have the national call center, so be it. But they do have to do the same reporting. And if we don't like what we see, we can deal with it at that point.
Mr. Baker, you've heard from a majority of the commissioners.
Yes, I have. Thank you very much for that. 1 minute, let me pull up our next topic. I'm going to defer the call center agents the next time we meet because I think we can do some work as a group together.
Mr. Baker, if you're still speaking, we've lost your audio.
My apologies. Sorry for my bandwidth problems today. The next issue I would like to take is there's language that staff has been supportive of that I believe the petitioners are not when it comes to notices of enrollment. And it has to do with identifying that the customer has to pay their previous bill provider for their previous charges, and that the notice should indicate if they don't pay those customers for those, that those charges could be eligible for credit and collections and possible service termination. So I would ask if the commissioners believe that they would like to see, if at this time they would like to see that, if they believe that that information is too much of a requirement or not. Staff believes it's good for the customer to be educated upon the seriousness of not paying their bills to the supplier or to their previous bill provider, because they still need to make those payments after the switch. But the suppliers argue that that's not a good customer experience to be receiving a notice from their new provider that states that if you don't pay the previous person, you could face credit and collections and possible service termination.
Mr. Baker, why would it be the responsibility of the new supplier to effectively give their new customer a lecture?
The idea is to keep the customer informed, and this would become on both the enrollment notice from the utility and from the supplier. And so I don't disagree with the position that this might be a little, that we are basically requesting the new provider to warn them they need to pay their previous provider. But at the same time, if the previous provider is not paid, they will lose their service with that customer. We do have additional language before that in the notice that basically says they need to pay, but we could remove this idea of credit and collections and termination if you don't favor that. And I can also ask Ms. Knoll to put the language on the screen if you'd like to see it, but
To put it on the screen, perhaps we could hear from the petitioners as to their counter position.
Ms. Knoll, it will be 205307. We'll see. And this language is repeated throughout the regulations, so that's why I would like to, I think it would be good for us just to either accept it or reject it. And so it would be the second half of that sentence in A2.
Mr. Baker, when you say second half,
Starting after "and that failure to pay the previous billing providers may lead to credit and collection activity and possible service termination depending upon the nature of the charges."
Okay. Mr. Green, do you wish to respond?
I do. I'm not sure what it's on my screen, what's on this screen are the same, but basically this type of language appears in 3 or 4, if I recall correctly, different areas of the COMARs of what the new supplier must tell their new customer who's coming from somewhere else, whether it be from another supplier or from SOS or sales service. And our position is that we don't have a problem telling the customer in the notice that they may, the previous billing provider may continue to bill them for unpaid charges. But anything after that, that failure to pay may lead to credit and collection activity and possible service termination, that's not a good customer experience to begin the relationship. And nor is it our responsibility. There's a prior provider and there's a payment issue, they can take care of that. It's not the new supplier's responsibility. So we would, in wherever this type of language, we were proposing to more or less cut this sentence in half. Like I said, after the word charge, I think.
Okay.
May still bill the customer for unpaid charges, period.
I agree with you. Commissioners, thoughts on this item?
Agree with the commissioners.
I also agree.
I agree too.
Yes.
Consensus item, a rare consensus item, 5-0 on this one, Mr. Baker.
Thank you. We will clean that up in the other parts. I do have one bigger topic that's not requiring us to go into wordsmithing that I think we can tackle if you still have the desire to, Mr. Chairman.
Yes, please. I would like to leave a little time. I know you're going through your list and you weren't expecting to go through this list as quickly as you had planned for, and not today. But if the parties had any quick requests of the commissioners at the end. So we'll continue moving through your items, but we are going to plan to adjourn by 3 o'clock today.
Okay, thank you, Mr. Chairman. This next item I would like to discuss is a proposal from, actually, no, I'm not recalling the issue with, I don't know if the utilities oppose it, so we can ask them. The petitioners have proposed to include within the customer protection sections a requirement that if a customer receives a termination notice from the utility for previous charges that were unpaid, that the supplier be given 10 days notice of that, be given 10 days notice that that is occurring. So, and then the suppliers, I presume, would go and work with the customer to make sure they understand that that's happening and that they can help them get payment or anything else. But so the supplier is forewarned that such an action may be occurring. This proposal came in, was not discussed during the work group process. It was briefly discussed before this hearing back in November. But staff was supportive of this idea, but staff did not think that it needed to be listed in COMAR. I do not know where the other parties stand on this issue if there's opposition to it. But if the commissioners believe such notice is appropriate, I think that would be good to know, and then the group can decide if it needs to be in COMAR or not.
Do other parties feel that this notice needs to be in the regulation? Mr. Trout.
Oh, I'm sorry. We do not feel it needs to be in the regulation, and we, in our written comments on December 4th, had issues with this proposal, which I think those comments stand on their own. But if the fact that this was raised late in the process and without any discussion among the parties, to me, suggests it's an issue that ought to go back to the work group for further discussion to see what, if anything, is going to be done with it. It certainly does not belong in the regulations, but if there are legitimate needs of the suppliers to receive some sort of information about terminations, and it's information that we can provide without further delaying or overly complicating what is already one of the most complicated, heavily regulated, fraught with delays processes that the utilities engage in, we would be happy to discuss it.
I don't hear any stakeholder advocating for inclusion of this notice in the regulation. Do any of the commissioners disagree?
I just want to ask the clarification. Would this, under supplier consolidated billing, would this be 10 days additional added on to the end of the various stages of notification and disconnection processes for supplier consolidated billed customers as opposed to utility? In other words, would those who receive a supplier consolidated bill get an extra 10 days of length before actual disconnection than a utility consolidated biller would under this proposal?
If my understanding of it is it should not. This should happen before. This should follow the same time frame, and I will let Mr. Green speak to that if I have mischaracterized.
No, that's right. All we want is a heads up before one of our customers' service is terminated, and we're not wedded to the 10 days. But when my clients went back as we were preparing our comments and got additional comments from leadership and so forth, they thought, well, we would really like to know that from a customer experience standpoint, that one of our customers is about to get terminated and perhaps we can help them. And so it wasn't intended to delay anything. It wasn't intended to increase any costs for anybody. It was simply intended as an additional positive customer experience, so we can help a customer that might in some way, or at least just have a heads up, even if it's a larger customer from our own business aspects that may have an input in it as well. But really, it was a customer experience issue, and it's not intended to be anything negative at all.
So, Mr. Green, you're going to help a customer. A supplier A is going to help a customer with what they owe to supplier Y. Is that what you're saying?
No, they may owe it. No, it would not have owed it to supplier Y. These are utility charges that the utility is continuing to seek recovery for from wherever they were before. So it could be coming from SOS or sales service. It could be coming from a different supplier, but then those have been sold back to the utility. But really what we're talking about, I think, mostly is from a customer that switches from utility service to an SCB supplier.
Yeah, but isn't that taken care of with that they don't have more than 30 days worth of arrearages? I'm kind of confused as to why we even talking about this, because if you're not I thought you were talking about, I don't know exactly what we're talking about here, but I'm a little confused as to where this even comes up, because if somebody's in arrears more than 30 days, they're not even allowed to sign up anyway.
Right. So you could still have arrears for less than 30 days. And then also that the utility
and not be disconnected for them. That's almost impossible.
Right.
That's almost impossible. I think this is not. I think this is a solution looking for a problem, in my view.
I fear we are losing the forest from the trees here as we whittle down these remaining issues. I don't hear any degree of non-consensus among the parties here, Mr. Baker.
All right. Thank you, Mr. Chairman. My apologies. I think at this point, because I would say 1 minute.
Mr. Chairman, while Mr. Baker's looking, and Mr. Baker, I appreciate, you're pulling this together. I have to say that I do have some questions sort of bigger picture issues with respect to what goes on the utility bill or on the supplier consolidated bill. And I think there's a lot. I've been looking at the regs and to me, it appears that the petitioners are seeking to keep utility information like utility phone numbers off the bill, that the only number they want to include on the bill is if you smell gas, or you see a wire down, call this emergency number. And I have a real concern with that because, as I've said before, I think the utility retains, it's still the utility's customer as well. So it seems to me that that the utility's phone number, if a customer wants to call the utility, it should be on the bill. So I have some concerns with that sort of on an overall customer experience just related to the customer experience. It doesn't have to be, front and center in bold print, but I think it should be there if they really want to call the utility. So that's just a highlight of something that may be to come.
And we can certainly take that issue if you would like to take it now, Commissioner Herman and the remaining commissioners. Again, Ms. Knoll can pull up the language and I can discuss the concerns in that area and what the work group talked through on that.
Let's proceed. I'm not sure if we have Ms. Knoll at the moment, so we may not have her ability to screen share.
Oh, okay. Then give me a minute. I will direct you to the page inside the. Did Ms. Knoll share with you revised regulations from this morning, Mr. Chairman?
I don't believe so.
Okay. Oh, here we are. This would be in 205309. Okay, Ms. Knoll, please. I think it's at the bottom, if you don't mind scrolling a little. Okay. This would be, yes, thank you, C and D. So a summary of the issues. So while the work group was discussing what should go on the bill, there were a couple requirements that what the utility is required to provide today to the supplier that were under dispute as to if it is necessary to include on the supplier's bill going forward. One of the biggest issues was the utilities number for the utilities number that is required to make billing payments. And that's effectively the utilities customer, and in turn, what this really turns into is the utilities customer service number that they're required to provide. The utilities believe that number should still be provided. The suppliers oppose it because they want to be the first contacted in this scenario and don't believe they should be providing the utilities contact information. While we were discussing this in the work group, a compromise was reached or I would say a perceived compromise was supposedly reached where a utility could provide that number, that billing phone number, which in turn is really their customer, which is also usually their customer service phone number, but they would not describe that number as the number that can be contacted for billing inquiries or other issues. So basically they could not describe that yes, put the number on the bill, but they can't, they should not describe it as the billing number. I believe the petitioners oppose this, and so staff supports this number being on there because there are reasons why a utility or a customer may need to contact the utility unrelated to billing, and also just per the fact that there is the issue of a customer needing to possibly discuss the distribution charges. So staff still supports the inclusion of this language, but is opposed by, I believe, at least the petitioners. And with that, I'm available for questions or clarification.
So Mr. Baker, this says that if a utility provides a phone number, so that's if it's up to the utility and not up to the supplier? I'm confused by the language in
So-
C here.
So this would be, so the utility would send the information. This is part of the information a utility would send to the supplier to print on the bill. We could create a requirement where it's just a known piece of information that always has.
Yep, lost you, Mr. Baker.
My apologies again. Am I back? Can you hear me now?
I can, thank you.
Okay, my apologies. The issue at hand is not, the utility will have to provide any information that they want on the bill to the supplier. And one of these pieces of information could be that customer service billing phone number. And so when they're providing that information to the supplier to put on the bill, it just would not be described per this COMAR as the number that would be the billing. Basically, they couldn't describe it as the billing phone number. And so
they would describe it as just sort of, here's the utilities, they would just put a phone number in there. I mean, usually it's called, I think, customer service and are you saying that customer service is objectionable to petitioners?
that is my understanding, yes.
Okay. Again, I do think that the utilities phone number should be on there. That's just my view, and my colleagues can move ahead. You don't have to answer me right away, but I'm looking at 7505B, and so just make sure that everything that the statute requires is on the bill is in this list. I think it probably is, but just, when you're going back and looking at this list, do a confirmation that 7505B is included. I just, that's my view, and I feel pretty strongly about it. So I'll just let my colleagues comment if they care to.
I agree entirely with Commissioner Herman on this point. It's rather frustrating as a utility regulator that we need to delve into this level of detail when I would expect that jurisdictional entities would employ common sense in terms of the sharing of information, and that we don't have to waste time, and I emphasize waste time, on dictating whether it's a billing number or a customer service number. I'm disappointed that we're having to debate this right now. I agree entirely with Commissioner Herman.
Ditto.
I generally agree, but again, this whole exercise is about competitive billing, and so let's not, start to micromanage exactly and determine what these bills have to look like. I agree that there should be some basic information. It should be provided in a reasonable location. I mean, if you look at your bill now, you flip it over, and there's all kinds of stuff there. So if that's what we're talking about, making sure some of these bits of information are available in this 7-511 requirement, then I'm okay. But again, let's let the suppliers provide their competitive billing product, and not, again, over micromanage the whole process. That's how I feel.
I also agree, and I think it's, as I noted earlier, the more important piece for purposes of SCB is that for billing related questions, even the utility should direct customers to the supplier first, to have the first opportunity to respond to the customer's questions. And then if it turns out it's related to something that the supplier can't answer, then it can go back to the utility. And the number should be there for a range of other reasons, of course, safety related matters, things of that sort. So I think it has to be there. As long as we clarify throughout in other places in the regulations that suppliers answer billing questions first.
Mr. Baker, you've received input there, and I would only go so far as to say that I envision the retail suppliers to be competing against each other, not necessarily be competing against the utility. And that's where the focus of the supplier should be. Mr. Baker, what do we have left before we provide an open opportunity for others?
Thank you, Mr. Chairman. I think at this point we can probably I think we've addressed a number of issues that we can take back to the group and work through and see if we can come to compromise on issues. If there's other guidance the commission would like, or other subjects that you would like me to go into at this time, I'm more than willing to do so. But I think that would probably be a better use of our time, is knowing where you would like to point us over the next month or two.
As noted by Commissioner Linton, the regulations are intended to go live and effectively have supplier consolidated billing in effect by January 1st of 2023. So just a little over 2 years. In adjourning this rulemaking session a little early, it's not my intent to delay our discussions here. How long do you think the work group would need before we come back? A few weeks, a month?
I would not reconvene. I would propose we do not reconvene the group until at least the end of January. I know a number of parties indicated when we were discussing Mr. Green's proposal that the next 2 weeks were probably off the table for meetings. And so that would give us at least 4 weeks. But if we wanted to have 6 serious weeks to discuss these issues and bring you back a well thought out proposal, I would request more mid to late February, not to delay, but to actually dive into issues that you've given us.
I understand what you're saying, Mr. Baker, and I appreciate that. I know the team has been working hard in the evenings to digest and synthesize positions, and negotiating positions and leverage of parties have continued to change based on the input of the commissioners. As I've stated throughout, the commissioners' positions have been communicated via informal votes. Commissioners may change their position before we actually call a final vote on the proposed regulations. Do the other parties, either the utilities, the state agencies, or the retail supply interests, have any requests of the commissioners while you have us? Mr. Green.
I don't necessarily have a request. I just wanted to respond to Your Honor's comment at the beginning when we adjourned about seeking guidance earlier than the actual rulemaking. And I accept the fact petitioners in any party could have asked for or requested guidance. And I just wanted the commission to know that this was an issue that was brought to the working group last summer. And without divulging too much, the bottom line was that the will of the working group was not to seek guidance on specific issues, but that the commission would be better informed with the total package. Rather than, because as you can see from the last couple of days, these issues can be very interrelated, and there's a real balancing of interest throughout the entire package. So I felt it necessary to let you know that the working group had this discussion, and that's, the decision was made by the petitioners and I guess the working group as a whole and each individual party not to seek guidance. So I just wanted you to know that that's not, it was something that has been considered before today and just didn't happen.
Thank you for sharing that. These rulemaking sessions are not a game of gotcha. We recognize the parties have been working hard. This is a very important issue, as Commissioner O'Donnell articulated. This is the will of the legislature, and we made clear how important supplier consolidated billing is to this commission in our order from last year. Mr. Baker, I'm going to designate you as the lead. After you gain consensus from the parties, if you could communicate with the executive secretary in terms of getting this item back on the schedule for us in January sometime. Do other parties have requests of the commission? Well, I wish to thank all of the stakeholders and my colleagues for muddling through these regulations over the course of the past 3 days. Obviously, the parties have different principled positions with respect to the regulations that we've been reviewing, and we will continue to review in January. But this topic is too important for us to rush through it so that we could get this done before Friday. And I am glad that we're taking some additional time to give these regulations the attention they deserve. With that, we will adjourn until such future time next month when we reconvene. This rulemaking session is now adjourned. Thank you.